Supplementary list, press admission, item number 1.
May I please your lordship? Petitioner in this case issue a very delicate issue regarding this ambulance services. Though there are several ambulance services, but they are not having exorbitant charges they are charging, and the government ambulance are also not taking the patient to the private medicals or the hospital, nearby hospital, for which a lot of patients are suffering. And similarly, in case of dead body, also they are charging exorbitant amount for ambulance services, for which poor people cannot take the service of these ambulance facilities.
Where are the examples? What are they being charged, sir? Can you tell us?
No, there is no regulations framed by the government.
Give us some idea of what is the charges.
Charges
tell us something, sir. Give us some examples.
Yes, some example like, my lord, if somebody wants to take their dead body to Puri.
No, in your petition, sir. Mr. Bali.
My lord.
We have to look at the pleadings in your petition, sir.
Yes.
In the petition, where have you set out what are the average charges that people are being made to pay? Whether it's private ambulance, which city, in Bhubaneswar, what it is, in Cuttack, what is it? Can you give us a sampling?
No, there is no average charges they are charging. They are charging according to their own schedule.
No, Mr. Bali, you'll have to work more in a more detailed, systematic fashion. It's a good cost that you're bringing, but you have to bring it properly. All right. You have to do some homework, Mr. Bali. You have to do some homework. You have to give us some empirical data. Give us some empirical data. Do some research. Do city-wise in Orissa. Find out what is the public ambulance facility available. What are the private ambulances? How much are people being made to pay? And for distance-wise, how much are they being able to pay? Made to pay? Do some. So you'll have to do some spade work.
No, that I can add by additional affidavit. With supporting documents, I will give it.
Not like that, sir. You'll have to draw up a proper petition. You'll have to draw up a proper petition.
No, there is no regulation. No, there is no regulation, and Supreme Court judgment I have annexed.
Sir, you may disagree. You may disagree with me, but the point is that your petition is very sketchy. It has to be filled up with greater number of details. Please withdraw it and file a proper petition giving elaborate details, sir. You'll have to give a lot of details.
There is no such.
This is too sketchy, sir. This is too sketchy for us to pass.
Your lordship, kindly have a glance to the Supreme Court judgment. There is no
judgment cannot be the basis for entertaining
a PI on the same issue
based on facts, sir.
No, on the same issue regarding charging the making exorbitant charges. There is no specific charges. Also in the
if there is already a judgment, we need not entertain a PIL. Then that judgment is enough.
No, they are not framed the rules according to the judgment.
For that, if you want that to happen, sir, you have to give more details.
No, details is not required. Let the government say. Let the government say what they are taking and what they are charging and what regulations they have.
Although the cause brought forth in this petition is a laudable one, the petition is totally bereft of details to enable the court to appreciate what the exact issue sought to be projected is. Full stop. Since the petitioner is complaining of exorbitant charges demanded by private ambulance operators and seeks a regulation of that practice, it is necessary for the petitioner to do some spade work and place before the court samples of such instances across Orissa, giving an idea of how much is charged by a private ambulance operator.
There is no
short of such specific instances,
average charges.
It will not be possible for the court to issue any meaningful directions in a petition of this nature. Permitting the petitioner to file a proper petition, giving complete details, this petition is not entertained and is dismissed.
Your lordship can call for the data from the government, my lord. How can I produce? It is the duty of the government.
List item number
there
2.
will be no PIL then. It is even if it is a valid PIL. So if somebody, how a private person can give data, all these data? It is the duty of the government. They can provide the data.
Item number 2.
PIL is become redundant. So how we can file any PIL to that effect? If your lordship sought for data, your lordship can sought for data from the government. Ask for the data from the government. They are the authority concerned. How a general public can provide such data? And the Supreme Court nowhere in their judgment sought for any data from the petitioner or from the also government. They said that you frame a regulation so that it can be regulated and nobody can be suffered. And in Odisha, lot of examples. Danomaji, I have given the Danomaji example. He brought the dead body of his wife by a bicycle. I have given the example of Danomaji in my petition.
Supplementary list item number 2.
So many data is to be provided by the person concerned to file PIL.
Carry on, sir.
My lord, in fact, there are 16 writ petitions akin to the one before your lordships today. The questions of law involved are the same. Now, there are certain documentary infirmities which has crept into the writ application.
You want to correct them, you want to withdraw and file a proper one, you can do it.
I will do that, my lord.
All right. Counsel, the petitioner seeks to withdraw this petition with liberty to file a properly constituted petition.
And let all
Giving
the
full
matters,
particulars in accordance with law, disposed of is withdrawn with liberty is paid for.
can I request your lordships to bring all the matters together so that
First
in
you
one
file a
go it
petition.
will go?
Yeah, first you file a proper petition, then we'll do that.
Supplementary list item number 3.
Well,
Item number 3, I have been permitted to withdraw this application.
Counsel, the petitioner seeks leave to withdraw this petition, dismissed as withdrawn. All right.
Supplementary list item number 4.
May I please your words? The petitioner in this state petition has approached this honorable court with 2 grounds, my lord. One is that I am an assessee, income tax assessee. I submitted my return for the assessment 2021 and claiming refund annexure to pay at rupees 2,95,440, my lord. They have not giving my refund and they have adjusted it without giving any so cause notice. Why there is an adjustment? Because for making an
What do
adjustment.
you say, Mr. Sarpati?
Yes, Lord. Lord, the refund has been adjusted towards the earlier dues, Lord. That is permissible. And Lord, if he has been agreed, Lord, he may file a petition to rectification of defects so far as 143(1) intimation is concerned. Or else he may challenge. He has challenged the your lordship see. He has challenged the intimation under 143(1) annexure 1. He has not challenged other thing. Kindly see the prayer. He has challenged annexure 1 intimation under 143(1) issued by the CPC Bangalore. There, my lord, he has disallowed some addition, some deduction, and now he's claiming that he's challenging that order before your lordship on the ground that some adjustment has been made.
Without prior notice to him. That's
But
what he says.
here is not they have the authority to adjust any previous due as per the notification 74 and 75.
No, without any notice.
No, that's not because if in the portal there is a outstanding.
No, that's whole as it is, it's portal. So there's no the assessee is usually taken by surprise. Suddenly he finds online something has happened.
Before that, he has to give a notice for a demand. He may not, my lord, I don't, yesterday I have received,
So you take instructions. You said
I take
notice, Mr.
instructions.
Sarpati accepts notice on behalf of the opposite parties and states that he'll file a reply within 4 weeks, rejoined if any before the next date. It's
No
done.
course of action.
8th September, sir.
No course of action. The demand is there, man. 34,000.
No, already adjusted. Your whole case is it's already been adjusted.
When they are making adjustment, then make a demand.
Let us
Therefore,
see if they
therefore,
make a
I
demand, we'll see.
Therefore, he has to file appeal.
How you will file appeal? Because
246 is there.
because region has been mentioned at page 21 that they are adjusting.
I thought your grievance was that we've already adjusted, correct? So anyway, so what can be done now?
Supplementary list item number 6.
What happened to file? Oh, he's took an adjournment. Correct.
May it please the Lordship. Lordship wanted to know the ground situation in this writ application because there is a case of unauthorized encroachment of 9 years since the Tahsildar first initiated a proceeding under the unauthorized encroachment and under the OPLE Act. Then the executive officer initiated for the self-same property. They have initiated under Municipality Act. what is my submission is, my lord, this
Who
Tahsildar
are you,
cannot,
sir? Who are you?
my lord, I'm a local person. I have filed this PIL.
No. In what correct? How are you connected with this?
My lord, before your lordship, I have appeared. Then I have
No. What is your
my lord,
interest in
I'm
this?
saying this is not the correct format. The Tahsildar should initiate the proceeding under OPL Act. It should be under OPP Act because
No.
in
Why
the-
are you? Who's the petitioner? What is his interest in this?
I'm a
whole
local
case?
resident of that area, my lord.
So
I'm concerned with the public premises which have been occupied since last 9 years. And admittedly, there is two proceedings which is pending till now, my lord. So that is my grievance. my lord.
That is wrong statement, my lord. Both the writ petition has disposed of. One is dismissed, another one is.
My lord, I'm talking about the proceedings which have been initiated.
no. You've only selectively picked up one, is it? Just come to your internal page 5,
My lord.
the second paragraph.
My lord.
Can you read it, please?
My lord, I have gathered this information from RTA
Can you
report.
read it, please?
My lord, for the sake of just an instance, it's gathered
So
from.
only one instance you're just picking up and making it a PIL.
No, my lord, I have gathered this information from RTA because this information,
Where
why
did you
this
get
is
it?
valid, my lord.
Who gave it to you under RTI?
Lord,
Where have you said that?
Previous paragraph, page 5, Peter.
No, but why have you picked up only one instance?
Yes.
Lord, because this is relevant because of the jurisdiction issues, my lord.
Meaning?
I'm saying the in the urban land, my lord, for eviction of unauthorized.
Why have
encroachment-
you targeted only one person? So he's going to come before the court and say only, why are you targeting only me? If there are so many unauthorized occupants, why are you targeting only me? Will not that be the first question that he'll ask? Why are you being selective?
Because
As a
this is-
PIL petitioner, if you start deciding, okay, there are 10 unauthorized occupants, I'm going to only focus on one. Even a court will ask you, why are you selectively being, why are you choosing only one person?
because this is a matter, my lord, relating to the jurisdiction issues, my lord. So I have gathered this information because this is relevant to the jurisdiction issue of OPP and OPL Act, my lord. So this is relevant in this situation, my lord. My lord,
Two
It's not
notices have been.
relevant in this situation. Why aren't you answering the question? Why are you being selective about one encroacher when you yourself say there are several encroachments?
my lord.
Why are you selecting only one, sir? On what basis do you select only one?
In this particular case, my lord, they have initiated two proceedings. And in this,
You're
out
not
of-
answering the question, sir. Are there more than one
my
encroachment?
lord, my prayer is absolutely to this point, my lord. Whether the unauthorized encroachment proceedings should be initiated under this act or that act.
No.
This is my prayer, my lord.
There are
not
going to be
regarding
people.
to this
So
person.
once we entertain your petition,
My lord.
there will be people affected.
No, my lord.
Nobody will be affected.
No, my lord.
Why?
Because this
You're not
person is
interested. You're not interested in removal of encroachment.
Yes, my lord.
Ah,
I have paid
If
this.
X is encroaching, Y is encroaching, Z is encroaching, and we entertain your petition, will they be affected or they will not be affected?
My lord, the person involved in this petition, this opposite party number 6, Lord, why I have given this instance? Because this is only relates to the jurisdictional issues and nothing to this opposite parties, my lord.
What are you saying, sir? Are you not interested in removal of encroachments or you want an academic exercise?
My lord, I don't want any anomalous situation, my lord.
What?
Where two proceedings are pending in two different acts.
You are not interested in removal of encroachments.
No, my lord, a guideline can be issued.
So you're not interested in encroachments being
my
removed.
lord, subsequently.
What is that subsequently? I fail to understand. The whole purpose of filing this petition is for removal of encroachments on public land, correct?
My lord.
You don't want that
But
prayer?
when the jurisdiction issue comes up, my lord, then ultimately, if they finalize this proceeding,
Sir, this is where the bona
that would
fides
be out
get
of
tested.
jurisdiction, my lord.
See how shifty and vague you are in your replies. This is where the bona fides get tested. Everything's dressed up as a PIL. This is what makes us suspicious what the real motive behind the petition is.
My lord, kindly.
If it is a genuine public interest litigation, you should be able to give at least 20 such instances, 10 such instances, make them parties, do some homework, not like this selectively. Just pick up one person, make him a opposite party and say, let's now start a PIL.
My lord, on the
This
last,
is the misuse. You've read enough judgments of the Supreme Court on misuse of PIL.
my lord, I have cited one of our High Court judgment where it is said that it is clearly said that in an urban land, the proceedings should be under OPP and not
So
under
we're not
the OPA.
inclined to entertain this PIL in this form.
My lord, let the state file the ground report, my lord,
Okay.
what the lordship wanted.
This petition dressed up as a PIL purportedly seeks the prayer of removal of encroachments from public land. However, strangely, only one instance of an encroachment has been picked up by the petitioner. And that person is sought to be impleaded as opposite party number 6. So the court repeatedly asked counsel the petitioner why the petitioner was being selective about only one person's encroachment and not concerned about the other encroachments. So there was no convincing reply forthcoming from the counsel of the petitioner. Full stop. In the circumstances, the court is not prepared to entertain the present PIL in the present form. It is dismissed.
Okay. Supplementary list item number 7.
Person may be permitted to withdraw matters.
Counsel of the petitioner seeks leave to withdraw this petition. Dismisses withdraw.
Supplementary list item number 8.
May please, my lord. My lord, this is a PIL matter. My lord, the petitioners are the villagers of the Puruna Pradhan village. My lord, the plot number 263, that is at page 10. Page 10, plot number 263 is a government land. And during rainy season, the flood water flows through the said passage, plot number 263, which, my lord, helps the villagers in harvesting their crops without the threat of any flood, without any threat of flooding, my lord. Now, my lord, the opposite party number 5, private organization Kalinga Bharati Foundation, my lord. And the Kalinga Bharati Foundation has illegally occupied the land and has made some construction over it, which will be revealed from, my lord, Annexure 3 series.
You made a representation.
Yes, my lord. Annexure 6, Annexure 4, I have made representation in the year 2020. Annexure 5 was also made in the year 2020, and Annexure 6 is the representation made this year, my lord, 5/4/2022.
All right. You say the petitioner's representation dated 5th April 2022 will be examined by the collector for and after issuing notice to the petitioners as well as opposite party number 5. And after giving them a hearing, a reasoned order shall be passed thereon, not later than 9 September 2022. The court clarifies it has not expressed any view on the matter.
Supplementary list item number 9.
May I please, Your Lords? The petitioner is an educational institution, my lord, and getting registration under section 12A of the IT Act, being exempted from paying Income Tax Act under section 11(5), the expenditure is allowable, my lord. In that case, my lord, what has happened? Notice under section 148 has been issued, but that notice
Joint
no
CIT.
My lord, it matters applicable. Assessment order has been passed.
When was the assessment order passed?
My lord, 148 notice is not signed by the authority. It has a plain notice issued to me, my lord. And they have issued notice in 142(1) prior to 10 days of filing of the assessment order.
Order has already been passed.
I have also given time application for adjournment. They have not considered it.
No, Mr.
They have
Patnaik, he says, Mr. Patnaik, he says an assessment order has already been passed. Is that right?
My lord, that assessment order is passed without proper hearing to me, my lord.
What about?
Because I have giving application for adjournment.
You can
Within
always
80 days, they have
assail it
passed
in
order.
appeal. You can assail it in appeal.
My lord, that can be within 80 days. That can pass the order by raising huge demand of 1 crore.
Yes.
So when I approach the appellate authority, then you pay 20% of that amount, my lord. That is my fault. I have already approached by filing a adjournment petition. Please provide me 80 days time to substantiate the issue. But he is bringing some materials from outside and utilize to me without providing that document to me. And what happened if you once again issue the notice and I will appear and produce everything? That is the wrong, my lord. This is educational institution, my lord.
1 minute. Page 47.
47 annexure 9, that is assessment under section 144.
1 minute. Sir.
That,
1 minute.
that is expected.
1 minute, sir. Come to column 8.
And
Column 8. Page 47. Just see column 8 there.
date and issue of a notice. They have issued a notice.
There are many
different
dates.
dates, my lord.
Ah.
So when they have issued the final notice, the draft assessment order should be there. After passing draft assessment, or they should have given me opportunity of being here. They have given me an opportunity. I have sought for adjournment. They have not allowed me. They have completed the assessment basing on the evidences.
1 minute. 1 minute. What was the date? What are the dates for that? When did they give you the draft order?
That is annexure 8 is my time petition, page 46, my lord.
1 minute.
That is on dated 21st March 2022, my lord. After 10 days, they passed the order, my lord. I have sought for adjournment.
No, you're only sought 7 days, sir. They've passed it after 10 days.
My lord, they have not allowed the time. I have every chance that what they have proposed to make addition against me, they might have issued a notice to
file
me.
an appeal, I think.
The third party information is there.
How do you expect him to reply within 7 days, sir? What was the tearing hurry? Come to page 46. He has asked you for 7 days. Why doesn't it go? We'll send it back for a fresh assessment. Give him one more hearing.
The page 48, page paragraph 4. There at the so cause notice under section 144 of the Income Tax Act.
No, that's right. You sent him a draft order. He's asked for 7 days time. Could have easily given him time.
Pass the draft assessment order.
Correct.
The SSC has submitted on 11/3/22 that the trust has received 1 crore as an secure loan and 70 lakhs and donation from general purpose from Mrs. Vidavati Educational Trust.
That is their allegation, department allegation. That is the department.
Just see the last 5 lines. On the fixed date, 21st March.
21st March 22.
The SSC submitted that we are in the process of collection of information.
Lord, let me take instruction.
Okay, say notice, Mr. Chimankar accepts notice and states that he'll file a reply within 4 weeks. We joined up for the next date. Till the next date of hearing, no coercive steps shall be taken against the petitioner. List on 15 September.
Supplementary list for admission, item number 10.
May I please your lordship? I'm on VC balance.
My lord, pursuant to the direction of this honorable court, the affidavit has been, we have filed the affidavit that we have no plan to frame any policy so far as settlement of this land in favor of the petitioners are concerned, because it was only a dafadari right was given to them only to enjoy the fruits.
Well, my lord,
the land cannot be settled in their favor. That is the only.
Here's the affidavit which has been filed. Your lordship sees the last order made by your lordship on the 3rd of March. Especially the directions contained in paragraph 7. Now, let's.
Yes.
Pursuant to this, yesterday an affidavit has been filed.
Yes.
Now, the affidavit states certain things which are absolutely contrary to the document which has been enclosed to the affidavit, which I showed to your lordship just now. Now, your lordship may kindly take paragraph 4 at page 2. Paragraph 4, the subpara there, it is pertinent to mention here that the language employed in the scheme is very clear and there is no ambiguity to the effect that to ensure an annual income of not less than 1,500 to each of the identified beneficiaries. The aforesaid being the purport of the scheme, nowhere it has been assured in the scheme that long continuance of plantation of the land would confer an indivisible right over the fruit land. Thereafter, the last sentence of that paragraph, Long continuance over the land by virtue of a scheme cannot make beneficiaries eligible to get the land settled in their favor permanently, which is very aim of the scheme.
No.
Thereafter, your lordship takes paragraph 7. That it may not be out of place to mention here that the scheme was introduced for 5 years. Your lordship may kindly take note of this word, 5 years. As per the guideline communicated to all collectors in Agriculture and Cooperation Department notification dated 21/8/80. However, due to efflux of time, the petitioner's right to enjoy the fruit has also been seized. However, as directed by this Honorable Court, there is no such fresh policy in this regard. Now, your lordship sees the scheme which has been annexed as Annexure A. Next page. Your lordships may take page 7. Page 7. Has your lordships got that?
1 minute. No, page, it's actually 307. Computer page is 307.
Page 7, the penultimate paragraph in that sentence beginning, the ASCO shall engage ERRP beneficiaries.
Yes.
As laborers for all labor-intensive work in such patch of plantation to be distributed amongst them. The work of maintenance shall be continued till the plantation reach the fruiting stage, and the cost shall be met out of the ERRP funds to be provided by the BDO. Thereafter, your lordships, over the page, column C, full Rayati rights will not be given in respect of the land mentioned in B above. Instead, only Dafayati right, this is what I'm seeking, will be conferred on the beneficiaries.
No, this was long ago, sir.
This is for a limited period.
I'll just show to you. That is not the purpose. Next page, page 9. Page 9, paragraph 4D. The benefits conferred under those orders are heritable. The plantations are also transferable only in favor of similar beneficiaries and not outsiders with approval of the Tehsildar. Thereafter, your lordship takes I. On conferment of Dafayati right, an annual fee of ₹1 per tree will be levied on each beneficiary by the Tehsildar.
So what was the date of this, sir?
1980.
So this is no longer, we are in 2022, sir.
Yes, my lord. But the question
this
here
can't continue indefinitely, this kind of a thing.
That is the purpose. That is what the scheme is all about, my lord. Your next page, your lordship sees. So long, this is important, my lords. J. So long as the plantation remains the property of the beneficiary, government may, after duly notifying him, use the land for any public purpose which is not inconsistent with the scheme and which does not create any difficulty for the beneficiary in enjoying full benefits from the plantation. K. So long as the above and the other terms and conditions as may be determined by the Agriculture and Cooperation Department for facilitating or expediting implementation of the scheme are satisfied, the plantation will remain the property of the beneficiary. Then last one, L. The plantation may be resumed by the government at any time if the land on which it is raised or plantation itself is required for the public purpose. In such an event, compensation for the plantation will be payable by the government in accordance with the principles laid down in the Land Acquisition Act. So, my lords, if your lordship sees the scheme as such, the 5 years is nowhere mentioned. What is mentioned is the government will enable the beneficiaries to develop the plantation. And after the plantation is developed, the plantation continues with the beneficiary for his life with a heritable and transferable right. That is the scheme, my lords. Because 5 years, if your lordship takes, that is the gestation period for the tree to bear fruits. So the scheme says that it will continue. It can be resumed for public purposes. Like any other government land, any other lease that the government may give, it may resume the land. But and it is made clear that it has to be in accordance with the principles laid down in the Land Acquisition Act.
May I submit, my lord?
Yes.
Yes. I would like to beg your lordship to draw the attention of the prayer in the writ petition. What is the prayer? Lordship may kindly see the prayer is, it is therefore prayed that the appropriate redirection and order so and so pass directing the opposite party to settle their respective plantation in their possession with the petitioner by issuing record of right in their favor. Now we have given certain land to, just a minute, certain land to them that you grow plantation over there and you have the right, you have the right to enjoy the fruits of that trees which you have planted. Now in the writ petition they say the land over which they are allowed to do the cashew plantations, that land should be record of right in respect of those lands should be issued in their favor by giving a royalty status. Because once ROR is published, they will be the royalty of that land and is the lawful owner of that land. So in this, whatever the argument my learned friend is advancing, that is regarding all the rights according to the scheme is only the fiduciary right, that is to enjoy the fruits. So far as the issuance of the very prayer of your writ petition to issue the record of right, that is not permissible. We have specifically stated there was a scheme in 1980 and for 5 years we have given it. You are enjoying and your enjoyment is confined to this. Your lordship has directed last order that whether you have got any fresh policy to recognize their right.
Why? Just read that order. Just read that order, Mr. Mohan.
Yes, my lord.
There's a purpose because we have noted something in that order.
Yes, my lord. Para 7.
Yes.
An interim order was passed in the present petition way back on so and so, directing the status quo to be maintained. As a result, for nearly 35 years now, the petitioner have been on the land, cultivating it and enjoying the fruits of such cultivation.
Yes.
In the considered view of the court, the state government should seriously consider whether
they're already there for 35 years.
Yes, my lord.
They've been cultivating.
The direction is that the direction is here. Court's direction is here. To consider, the state government should seriously consider whether a fresh policy or scheme needs to be formulated, recognizing the possession of the petitioners over the land in question for well over the decades. A direction is issued.
So there is something called de facto de jure. So de facto, they are on the land.
They are on the land.
Cultivating it, they're enjoying the fruits.
With a limited right.
No. So
not to acquire the title over the land.
Where do you want to take this forward? See, you're not saying give us back the land. You do not want to use that land for anything because the scheme says that if you want to use for public purpose, you can. But you don't seem to want to use it for anything.
My lord, we have already initiated encroachment proceeding against him, against all the petitioners.
Where have you said that?
They have sought for coaching of that encroachment cases. The second portion of the prayer may kindly be seen. The encroachment cases initiated by the OP number 4 against so and so may be given para 10, it may be quashed.
No, this was way back in 2002, sir. The stay has continued for 20 years now.
Thereafter, the status quo order is continuing.
Correct, for 20 years now.
My respectful submission is that let us assume for the sake of argument that they are in possession of the land in question. But my respectful submission is that what is their right? Their right is confined to the right to enjoy the fruits. Now the very prayer of the petitioners to get title over the land. That is what I am objecting vehemently. And we say that there is no policy.
How does this serve the purpose of the state? I don't understand. You say, I need this for X, Y, Z purpose, and therefore the land needs to be got back. I can understand. You're not saying that.
No, we are saying that
you are not saying the state wants this land for X, Y, Z public purpose. You're not.
That is why we have initiated the encroachment proceeding. Unless we
encroachment proceeding has nothing to do with saying that I need this land for a public purpose. Where is your stand that what do you need this land for?
Then I may be given time. I will file a further affidavit that for what purpose this land is required. Because we cannot part with the right title interest in respect of this land.
No. If you want them to pay something, they will pay.
No, that may be. But my
they anyway develop the land. See, they've developed the land.
They have only planted the trees. Still, and they have enjoyed the fruit of the.
No, you are making it seem that nobody is benefited.
They are highly benefited, my lord.
No, not just them. I'm just saying the land has been made productive. The land has got cashew plantations.
My lord, kindly consider, we have provided fund to them and they have only planted the trees and enjoyed the fruits. That is the scheme. This is for the purpose of, we have. My lords, yes, sorry. My lords, our only concern is once we open this door, then under many schemes, we have given land to various beneficiaries for many purposes. Everybody will come and you give record of right of this.
No, because for 35 years,
No,
the whole thing is, it's
it
not
is
that they start cultivating today and ask you to give you ROR next day.
Why this long time, your lordship may kindly, because of the status code, your lordship may kindly see, this writ was filed in 2002, 20 years back. By that, and encroachment proceeding was initiated, thereafter status quo order was passed.
Correct.
So,
and you've not moved to vacate the stay. Mr. Monty, this is what is the factual matter. There is something called a de facto.
That is there. Your lordship may say that why you have not applied for vacation of stay.
Correct.
Is there.
If you really needed the land, you would have asked for vacation of
But
stay.
the intention is not bona fide. My responsible submission is
What
that.
bona fide? Even their request is bona fide. They're saying you've cultivated for 35 years. If you don't need the land, why don't you give us the land?
Your lordship should exclude these 20 years because it is lease pendants. Only thing is that after the scheme is
or
over,
1980 to 2002 was already
Yes,
22 years.
that
No,
is
that is already 22 years. You're forgetting that.
now, why I am submitting, my lords? Because in similar type of schemes, many beneficiaries are
So why not? Which is why we want you to formulate a scheme.
But
Precisely, there will be several others. We are not saying make a scheme only for this petitioner. We are saying why don't you make a scheme generally?
In that event, we have to part with many valuable government lands also.
No, if they are being cultivated, you collect revenue from that on the sale of cashew.
We are
You
not collecting revenue. My lords, we are not collecting revenue. Rather, they are getting profit out of this.
No, you formulate a scheme where you'll get revenue from that too. Why don't you formulate a scheme so that
is
you are
for
not
the-
losing out?
My lord, it is a beneficial legislation for the people, for poor people of that local area.
Exactly. So you should come forward to say, I'm going to use this land for this purpose.
That does not mean that we will part with the right title interest in
If
that.
you have a genuine public purpose for which you need the land, please say so.
Yes, my lord. Specific direction may be issued, we will file affidavit.
See, the court has perused the affidavit. Stated, which page is that? Affidavit dated 21st June 2022, filed by the
Special Secretary Agriculture.
Special Secretary to the Government Department of Agriculture and Farmers Empowerment, stating inter alia that the scheme floated in 1980 was only for a period of 5 years, and that due to effects of time, the petitioner's right to enjoy the fruits open petition has also been seized, unquote. It is further stated that there is no proposal for any fresh policy,
Yes, madam.
in this regard. Paragraph, the court finds that the affidavit that does not address the fact as noted in the court's order dated 3rd March 2022. The petitioners in the present case have been cultivating the land in question for nearly 4 decades. Full stop. It is only after 2 decades of their cultivation when a notice was issued to them seeking to evict them, that they approached this court. Full stop. The status quo has continued pursuant to the interim order passed by this court for again 2 decades. Paragraph. Mr. D.K. Mohanty, then additional government advocate, submitted that if the request for transfer of the record of rights (ROR) in the name of the petitioners were to be entertained, there will be similar requests by several others who may have been granted land for cultivation by the government. Full stop. He further states that the government may require the lands for some other public purpose. Full stop. Paragraph. It is not clear from the affidavit filed whether the government requires the lands in question for any specific public purpose. Full stop. If in fact there is no such supervening public purpose for which the land is required, then the government should seriously consider whether in all such cases, where the persons have been cultivating the land for well over 3 decades, a scheme can be formulated which would be beneficial both to the persons undertaking such cultivation as well as the government. Paragraph. Mr. Monti seeks further time for instructions and to file a further affidavit.
May I request one thing? If this is the direction of the court, your lordship may dispose of the writ petition directing us to take a decision on this, and we'll take a cabinet because this needs a cabinet approval. So your lordship may give us time, 6 months time to take a decision on this. Whether this can be, because it is a policy decision. If any decision contrary to the scheme, now we will take, it needs cabinet approval. Scheme.
All right. At this stage, Mr. Monti states that the government will have to take a policy decision, which would take at least 6 months' time. Full stop. In that view of the matter, while directing that a policy decision be taken in the lines of as suggested by the court, that a policy decision be taken on the issue in light of the orders passed by this court on 3rd March 2022 and this order. The court directs that till such time the policy decision is taken, the status quo as ordered by the court earlier will vis-a-vis the petitioners will continue. Full stop. The policy decision should be taken within a period of 6 months from today, and in any event not later than. We have a 2023 calendar. Keep a 23 calendar now. Not later than 1st February 2023.
Fast. My lord, fast December.
1st February 23.
Oh, obliged.
The petition is disposed of.
My lord, direction be issued to communicate this order to the Chief Secretary from the registry.
A copy of this order be communicated to the Chief Secretary. Right.
Obliged. Very obliged.
Supplementary list item number 11.
Now, in this case, in view of lordship's last order, my landed sinner saw the copy of the petition. That some of the petitioner clause, they tagged with the record, they're quite old. Like was OJC 11406 of 98. So the records are not available. So our office may be permitted to get the copy of the records from your lordship's file.
All right, learned counsel for the state is permitted to obtain soft copies of the paper books from the registry by supplying a pen drive.
Man, there's a 1997 land acquisition proceeding. I can't answer unless I go through all the records.
My lord, this is that same matter where, my lord, an affidavit was filed by the Tahsildar saying that admittedly I have succeeded in the consultation authority. No appeal.
There's nothing like that earlier. Correct.
And my lord, they have proceeded first on an 11 and then issued me notice for taking the compensation without notice to me anywhere. That is the short point for consultation. And it was on 24th of April, my lord. And my lord gave them enough chance, my lord. And my lord, just I pray a short date may be given, my lord, so that a small matter, my lord, whether it is against me or otherwise, my lord, not take much, not engage my lord's matter for too long.
Basically, fraudulent title was in 1977. The compensation amount
that
was
not even a plea taken, my lord. During the land acquisition proceeding post 4, I have given patta by them, their own officers.
List on 6 September.
Deeply.
The connected matter actually, I think that the second item,
Yes,
WPC 10969 of 2005.
yes.
That I think has become infructuous.
It has become infructuous probably.
All right.
Because that is the land proceeding, my lord, for eviction.
I'm appealing
My
for
lord,
IDCO in that matter.
well, they should indicate, my lord, I'm sorry, my lord, my lord should indicate that the IDCO handed back possession to the revenue for whose purpose, the public purpose was IDCO, given for industrial development and tourism. They did not take it, they reverted it back. So since they reverted it back, it's back with the revenue. And therefore, my lord, the initiation of the proceeding under the OPL and under the Public Premises Act, my lord, becomes otious. That's the only point.
So anyway, 10969 we dispose of.
Yes.
That I appeal for IDCO that matter.
All right.
My lord, kindly, they have filed an affidavit, my lord, that we have handed over.
All right.
Right.
In WP Civil 10969 of 2005, you see Mr. SP Mishra and its senior counsel appearing for IDCO points out that IDCO has already handed back the land to the revenue department. In that view of the matter, the present petition does not survive and is disposed of.
Supplemental list item note 12.
I am for the opposite party. Kindly pass over, madam. Petitioner, madam. Kindly pass over, madam.
You for the petitioner?
Yes, madam.
Or
pass over, madam.
Retired already. Claiming regularization. Already retired. You are 46 years in 2008. Now 2022.
Anyway, let him come.
They are not.
Supplemental list item note 13.
Including the referent, any other day, some other day.
Or a counsel, the petitioner is stated to be in some difficulty today. List on 20th September, 20 September.
27 minutes.
20th, 20. Supplemental list item note 13.
May I please, your lordship? This matter, lordship. Present petitioner, while working as fiscal lordship, the present petitioner, while working as fiscal, met with certain allegation, lordship. He filed, he was suspended, he filed appeal, he lost. Thereafter, he filed writ petition before this honorable court. In writ petition, he succeeded. While passing order, this honorable court was pleased to pass the allegation and pass order directing the authority to impose punishment regarding deliberately avoiding accepting the notice. Lordship, the order passed by this honorable court is may I read, lordship, last part of the order. This is reported judgment, lordship. Last paragraph, just I am taking, lordship. Last paragraph. In view of the above discussion, my lord got the judgment order, my lord. Got.
Where is it?
That is reported into, that is I have supplied, lordship.
It's part of your written submission, para 7.
Lordship, in view of the above discussion,
That's a
while
page,
we find that the petitioner is guilty of the second charge,
Computer page 188.
he is not guilty of the first charge relating to interpolation of the order so far as question of punishment is concerned. Having found that the first charge relating to interpolation of the court's record has not been proved against the petitioner, order of punishment imposed by the disciplinary authority appears to be disproportionate. Accordingly, we also set aside the order of punishment as well as the appellate order and remit the matter back to the disciplinary authority to impose appropriate punishment, only considering the fact that the petitioner is found guilty of the second charge, that is for deliberately avoiding to receive the order of punishment. the disciplinary authority is further directed to pass necessary order regarding punishment within 2 months from the date of communication of this order. Let's see. Thereafter, kindly come to page 28, the punishment award. Page 28 of the writ petition, my lord.
Yes.
Sri Rath, senior assistant of the court, is imposed with the punishment of stoppage of 1 increment without cumulative effect as per the order of the registered judicial cum disciplinary authority by the order dated 4/12/2010.
What's wrong with this?
I am not challenging this, Lordship. I am not challenging this. But I am challenging, Lordship, pursuant to this order, the benefit accrued to me was not given. I was not given promotion. Let's see. Then kindly come to page 33, where I am aggrieved, my lord. Sri Rath, section officer of this court, is promoted to the post of superintendent level now redesignated as section officer with effect from 30/6/2006 against the superannuary post of superintendent level 2, now redesignated as section officer, created by the Home Department letter number so and so for the period from 30/6/2006 to 10/4/2012 in the scale pay of so and so, in order to implement the order of the Honorable High Court passed in so and so. The pay of Sri Rath will be fixed notionally, and he will not be entitled to any arrear differential salary for the period from 30/6/2006 to 10/14/2012.
Yes.
Let's see, my case is a gradation list. Let's see, page 26. A gradation list was created pursuant to the decision of the appeal committee. Let's see, that is at page 26. Page 26, my lord. Pursuant to the decision of the appeal committee and order of this honorable the Chief Justice dated 22/2/2001 and 19/4/2001, gradation list of the following senior assistant of this court is prepared after refixation of seniority. My name, Lordship, found place at serial number 19, my lord. Kindly consider. At serial number 19. But in 2002, Lordship, that is as page 30. Lordship got it, page 30. Promotion was granted to these people, ignoring my case. My case before my lord is, instead of granting me promotion from 30/6/2006, I should be given promotion pursuant to the gradation list prepared by the appeal committee of 2001, Lordship, where my juniors have got the promotion on 2002. For that purpose, Lordship, this honorable court on the last hearing directed the authority to file affidavit whether any junior to this petitioner were promoted and whether if his CCR is found to be not up to the mark, whether it was communicated to the petitioner. The reply filed by the authority lordship in the affidavit on dated compliance of the order, that is whether any of the junior first issue, the affidavit filed by the opposite party lordship, whether any of the juniors to the petitioners are promoted to the date of promotion in the of the petitioner in 2006. I humbly state that several juniors to the petitioner have been promoted to the post of superintendent level 2 prior to the date of promotion to the petitioner. This is, I felt aggrieved, my lord, since I succeeded before this honorable court, due promotion and salary benefit was not given to me, lordship. And second aspect, lordship, the allegation that the CCR was not up to the mark, whether it was communicated to the petitioner, that point, the reply was, lordship, in reply, whether adverse entries of the year 2004 were communicated to the petitioner or not, the answer is reply filed, the adverse entry of the year 2004 in the CCR of the petitioner were not communicated to the petitioner. Therefore, lordship, squarely I am covered by the Sukhdev case, lordships.
Mr. Murali, actually, there's a virtual admission.
In fact, my lord,
Those adverse entries were never communicated. That's what this affidavit says.
well, in fact, in 2004, there was no adverse entry at all. So where is the question of communication? That is our case.
That's not how it reads. The adverse entries of the year 2004 in the CCR were not communicated. That's what it
Yes. In the counter,
It does not say since there are no adverse entries, the question of communication did not arise.
in the counter affidavit, we have stated that in the year 2004, he has got good entries. In the counter affidavit, that is our stand.
Then, lordship, I must have given promotion.
Since he got good entries in the year 2004, he was given promotion in the year 2006.
No, but his juniors were promoted in the meanwhile.
Yes.
Then he should get the promotion from the date his juniors got it.
No, criteria is not seniority come merit. Criteria is otherwise. Merit come seniority.
Since he has retired, petitioner has
Actually,
retired.
there is a further paragraph. Just come to this internal page 4, bottom.
Page 4, lordship.
Of this affidavit you were reading out, state's affidavit.
Page 4, lordship. By 30th/6/2006, when steps were taken to fill up 9 posts of superintendent level 2 was considered, the petitioner had 3 good entries. Accordingly, the petitioner was given promotion to the post of superintendent level so-and-so by refixing the seniority. This is what they have given. My case is, lordship, since they are admitting up to 2004, I had got good entries. And when by that time, when 2002, they have considered, they must have considered my case because
Why aren't you reading the whole thing? You are just stopping by reading. You're not reading the whole thing.
Since there was no vacancy in the cadre, the state government was moved for creation of temporary post of superintendent level 2, now redesignated as section officer for the court's establishment. According to the state government, by order number so-and-so created supernumerary post for the said purpose. Thereafter, the seniority of the petitioner was fixed at the top of the cadre of the superintendent level to above Sri Achyuta Mahapatra section officer by so-and-so. He junior to me.
Yeah, so you've been fixed above him. You have been fixed above him.
In the gradation list, lordship, many juniors All juniors have promoted. Let's see kindly specific allegation. This one, let's see, kindly come to that gradation list, the page 26, let's see. Page 26. I am in serial number 19. 20, Parikita Sahu, S.R. Das, D.K. Chaudhary, D. Mahapatra, Dilip, they have Boilachand Das, they have all promoted above me, Lordship. Now they are continuing. Now, Lordship, kindly consider the Lordship, kindly come to page 36. Page 36. In exercise publisher for smooth management of official business, Sri Asit Kumar Mahathi, now section of now working as superintendent, is transferred and posted as superintendent copy section, Dilip Chaudhary superintendent section, promoted cadre of assistant register and additional stamp reporter. They are junior to me in the cadre list, let's see. And the gradation list prepared by my lord in the appeal committee. Therefore, my humble prayer, Lordship, since there was no, without cumulative effect, one increment was stopped, I must have given due promotion, Lordship. And arrear salary has not given to me according to the due promotion. Therefore, Lordship, I am falling under the case of High Court of Jurisdiction Patna, Samdev case, Lordship. Once they say my CCR is thereafter developed and good, I must have given. Now I am retired, Lordship. Due promotion should have given to me, and all back wages and arrear, Lordship. And my lord's query, my lord was also extended his service for another 2 years, finding his career is good after retirement.
Kind on to the prayer at page 24. On the basis of his seniority, he is claiming that he should be given promotion. Page 24, prayer number 1. Produce all relevant connected records for verification to ascertain seniority of the petitioner to accord him departmental promotion as superintendent level 2 from 3/12/2002 instead of 36/2006 as per his seniority. So his claim is on the basis of seniority only. Now you Lordship kindly turn to the relevant rules which I have filed along with my notes that is available at page 10. The rule governing the field promotion that is available at page 10 of my written note. The Orissa High Court Conditions of Service Staff Rules 1963, on page 11, Rule 6, Sub-Rule 2. May I please? Promotions shall be made on the basis of merit with due regard to seniority. So first of all, merit has to be considered. Thereafter, if he is found suitable, thereafter seniority comes. Now, your Lordship, kindly see my lord's noting at page, running page 51. As part of counter.
Yes.
This is the note which has been approved by my lords. Your Lordship, and page 52 bottom, your Lordship, page 52, second subparagraph in this regard. In this regard, it may be mentioned that on 2/12/2002, when the matter of promotion for filling of 21 posts of superintendent level 2 was considered, Sri Ratha, who was at serial number 6 of the gradation list of seniority, was not considered, not only for the pendency of the departmental proceeding, but also for persistent complaints made against him by the advocates, besides the entry in his CCR for preceding 3 years that his performance was not up to the mark. promotion in the High Court service cadres is always considered on merit with due regard to seniority. Hence, Sri Ratha was not considered for promotion in view of the entries in his CCR. The pendency of the departmental proceeding or subsequent results thereof has no bearing on the matter. Apart from that, the said findings in respect of Sri Ratha have remained unchallenged and thus have become final. It may be reiterated that the writ petition simply related to departmental proceeding. Thereafter, on 1/2/2005, promotion for 13 posts of superintendent level 2 was considered. But since Sri Ratha was already reverted to the lower cadre in the departmental proceeding, he was not considered. Similar was the case on 36/2006 when again promotion to the post of superintendent level 2 was considered. Now that the order of reversion has been set aside, it would be deemed that Sri Ratha was in the zone of consideration for promotion to the cadre of superintendent level 2 at the time of consideration on 1/2/2005 and 36/2006. It may be reiterated that promotion is considered on the basis of merit with due regard to seniority. Further, as per the guidelines issued by the Government of Orissa in DA Department, in order to judge the suitability of an officer for promotion, CCR and other documents available for preceding 5 years having a bearing on the performance and conduct of all eligible officers need be scrutinized, and the CCRs taking into consideration as above shall include CCRs covering at least a period of 3 years in preceding 5 years. In the aforesaid backdrop, the CCRs of Sri Ratha as on 1/2/2005 and 36/2006 is to be considered. Till October 2002, Sri Ratha had adverse CCR. He got a good entry in the CCR only on 10/4/2004 for the period from November 2002 to 10/4/2004. Thus, by 1/2/2005, he did not have 3 good entries in preceding years. By 36/2006, he had 3 similar entries. Thus, he could have been promoted while his cadre mates were promoted on consideration on 36/2006. In the premises, if approved, Sri Ramakanta Ratha may perhaps be given with promotion to the cadre of superintendent level 2 with effect from 36/2006, refixing his seniority. And since there was no vacancy in the cadre, the government may perhaps be moved for creation of a temporary post for the purpose. And this has been
that has been done.
Yes.
So that supernumerary post has been created.
Yes.
What is the difficulty in backdating his promotion? That's the only question. When his juniors got it, why can't he get it from that date?
Because he has no adverse, he was having adverse CCR till 2002.
That's right.
Yes.
So after which, when the promotions were made of the juniors, why can't he be given from the same date?
No, he was given from 36/2006.
No, but why not from 2002?
No, 2002 he was having adverse
No,
CCR.
till October 2002 only. He had adverse entry.
Yes.
From
No.
For this purpose,
Can
Lordship,
allow me to complete? He got the good CCR from November 2002 to 10/4/2004.
Correct.
After 2002, the next DPC came in the year 2005. By that time, only one good CCR was there. That is why in 2005, he was not given promotion. That we have stated, Your Lordship. At the cost of repetition, I am placing, Your Lordship, the same page 53, first subparagraph I am placing. In the aforesaid backdrop, the CCRs of Sri Ratha as on 1/2/2005 and 36/2006 is to be considered. Till October 2002, Sri Ratha had adverse CCR. He got a good entry in CCR only on 10/4/2004 for the period from November 2002 to 10/4/2004. Thus, by 1/2/2005, he did not have 3 good entries in preceding years. That is the main reason why he was not given in 2005.
And that is why, Lordship, this Honorable Court was pleased to direct them to whether you have communicated this CCR. Adverse
2004.
No, this was not adverse, sir.
Communicated.
No.
They filed, no, we have not communicated.
This is not adverse. What he's saying is you had to have 3 good entries. You had only 1. And it's not an adverse entry, it's a good entry. So it's a question of communicating under any adverse remark.
Yes, 2004, there is good entry.
Lordship, if I have got good entries, Lordship, what I am submitting, since there was allegation in 1999 against me, they purposefully they did not give me promotion, Lordship. But why I am saying so, Lordship, kindly,
Sir, your entries in CCRs you cannot change. You need
No, Lordship.
three good entries. You did not have three good entries.
Lordship, I did not have three good entries according to my friend on 2004, Lordship.
No, by 1 to 2005.
5. Prior to that, there was promotion, Lordship. Prior to that, there was promotion. That's what I'm begging, I'm praying before my Lord.
No, then you had adverse.
Lordship.
Sir, till October 2002, you had adverse entries.
My case is at page 30. Page 30, when my juniors were promoted on December 3rd, December 2002.
So this is if the juniors were promoted merely on basis of seniority, what you say is right. The promotion on merit cum suitability. Not on seniority, sir.
Lordship, that merit cum seniority was considered. Lordship, that what my learned friend is harping, Lordship kindly come to that. The Orissa High Court condition of service rule. That
is part of my written note.
Promotion to the various posts in the High Court staff shall be made by the respective appointing authorities. Promotion shall be made on basis of merit with due regards to seniority.
That's right, sir. So merit is the first. So merely because your juniors got it will not mean automatically you get it from that date.
Due regards to the seniority, Lordship.
Correct.
Now,
when they say merit with due regard to seniority, you can't elevate seniority beyond merit. First you have to see merit, then seniority.
Now, Lordship, my case is, Lordship, kindly come to again page 36, 3. How I am being aggrieved, Lordship. 33. What my learned friend submitted the notes, Lordship. Pursuant to the notes, Lordship, this promotion was granted to me on page 33. Page 33, I was given promotion, but I shall not get any arrear from 30/6/2016 to 10/4/2012. That is also being against me, Lordship. I am given promotion. Thereafter, they say from 30/6/2006 to 10/4/2012, we will not get any arrear. Then, Lordship, my increment, my punishment, kindly come to punishment. What was the punishment? Our page 31. Page 31, the punishment, Lordship. Absolutely nothing against me, the punishment, page 31. The increment of Sri Rath falling due. This is the only punishment. Due on
which anyway you said you're not challenging.
1/8/2011 is stopped without cumulative effect as for the order passed. Therefore, if one increment is stopped without cumulative effect, I shall be entitled to all benefits, Lordship. That was not revised. My salary was not revised. My salary was not revised. I was not given a benefit. So, kindly see, only one increment was stopped, Lordship.
All right.
Without cumulative effect.
Okay.
This was issued in the year 2013, but never challenged.
But all that is kindly, Lordship, kindly come to my prayer. Direct the opposite party to grant all consequential service and pecuniary benefit accessible and permissible to the petitioner during his service tenure. Lordship, what I am humbly submitted, being working before this honorable, if I have committed any wrong, punish me, Lordship. But don't they should not harass me by cutting my all pensioner salary benefit and revised scale of payment, everything.
All right.
I have succeeded before by this honorable court. My
All right. All right. Anything else? We'll just reserve orders. Orders reserved. All right.
Supplementary list item number 14.
Lordship, this is a case where the demolition drive of the ponds is
only
going
I
on.
say I'm covered by two judgments, Lordship. That is two judgments. Didn't have at 2 p.m. One is Lordship reported 2014 4 SCC 7773 Lordships. That is High Court of Judicature of Patna and some dear Lordships. That purpose is Lordship how when ACR or any conduct is not communicated wiped up by subsequent positive conduct and promotions. Lordship, another judgment. Sukhdev Behra Lordship, 2013 9 SCC 566 Lordship. Two judgments.
Item 14.
Lordship, this is a case. ମାଲ କମଉଛ ଗରିବ ଲୋକଟା କେମିତି ବଞ୍ଚିବ ସେଇଟା ଦେଖୁନି ମାଲ କମଉଛ May I please your lordship?
This is to be taken up as per the noting. It will be taken up 2 p.m. So I have asked my collectors to come. So
we'll reference some other day.
Yes.
Reference that.
Lordship, what we pray, the pond which they have demolished, let them file a counter to that effect. From the high tide line, they have demolished the ponds, Lordship. We, for the intervener applicant, that is our limited prayer, Lordship. The pond which they have already demolished by the Tahsildar Chelka and Tahsildar Tangi, Lordship, the petitioners want, let them file an affidavit to that effect, that only the high tide line, those ponds are there, that they have demolished. That is our whole.
In which IA you are appearing?
13647.
13647. I will get specific instructions so far as this case. 13647.
By 21. It was filed on September 21, Lordship.
Lordship may fix a date.
No demarcation,
Since there is
nothing
a
of any
reference at
sort.
2 o'clock today, it will not be possible to hear the matter today. List on. June, I think. 30th, there's nothing. 30th June, next Thursday.
30th June.
As your Lordship.
Next Thursday.
At 2 p.m.
2 p.m. Correct.
As your Lordship.
Supplementary list item number 15.
May it be your Lordship. I am the petitioner in the matter, my Lordship. Here the issue is, my Lordship, the Gochar land, alienation of Gochar land in favor of the company is under challenge, my Lordship. And that violates the orders of the Supreme Court and guideline of the Government of India, my Lordship. And I have mentioned in page 2 of my preliminary submission to the state, page 2, my Lordship. Page 2. Now, can I have a glance, my Lordship, on page 16? Page 16, annexure. Annexure 2, the directive of the Government of India circulating the order of the Honorable Supreme Court. Page 16, my Lordship.
Yes.
May I be allowed to read the to the Chief Secretary.
Carry on.
Sorry. To the Chief Secretary, Additional Chief Secretary, Revenue of all states, Union Territories, subject information regarding Gochar land. With reference to the caption subject, I am directed to bring to your kind notice The judgment dated 12th January 2011 of the Honorable Supreme Court in the matter that state of Jharkhand and others versus Pakur Janmancha and others, civil appeal number 436 of 2011, copy enclosed. In view of this judgment, you are required to kindly furnish the following information on or before 30th April 2018 for devising uniform national policy for Gochar land and further appropriate necessary action. Now, my lordship, we shall come to the order of my lordship. It is on page 18. Page 18. The order of the Honorable Supreme Court.
Yes.
It was in para 15. We should, however, note that such de-reservation of any government land reserved as Gochar should only be in exceptional circumstances and for valid reasons. Having regard to the importance of Gochar in every village, stop. Any attempt by either the villagers or others to encourage upon or illegally convert the Gochar to house plots or other non-grazing use should be registered and hardly dealt with. Stop. Any requirement of land for any public purpose, I repeat my words, any require of land for any public purpose should be made from available waste or unutilized land in the village and not Gochar. Stop. Whenever it becomes inevitable or necessary to de-reserve any Gochar for any public purpose, within bracket, which as stated above, should be as a last resort. The following procedures contemplated in Regulation 24 and 25, that is the Finance Act of the Jharkhand, and Section 32 should be strictly followed. Next paragraph. Next paragraph. The jurisdictional deputy commissioner shall prepare a note, public report, giving the reasons why the Gochar had been identified for any non-grazing public purpose, and record the non-availability of other suitable land as such public purpose. Deputy commissioners have sent the said proposal for de-reservation to the state government for its previous sanction. Now, my lordship, the issue is the alienation of Gochar land in favor of the company in page 14, my lordship. In page 14 of my agenda, in page 14. It's not a alienation in favor of the cement company. It's never a public purpose, my lordship. And the details have also not been followed and directed by the Government of India and the Supreme Court. Page 14. Page 14 and page 15, all Gochar land, they have been converted to Unnata Yogya Anavadi and have been surrendered to the company.
Yes.
Now, my lordship, and the details have also not been maintained for which public purpose the reservation has been made. So that is a complete violation of the Government of India's order, source of the orders of the Supreme Court. I have also annexed people orders of the Honorable Appellate in this regard, my lordship. Now, there has also been a violation of OPA Act, Section 7, my lordship. OPA Act, Section 7.
How long will this take, Mr. Mishra?
My lordship.
How long will this case take?
It is in the year 2019, I believe, my lordship. 2019. And I had also.
How long will you take to make your submissions? How long will your arguments be for?
My argument is very concise, my lordship. It's a,
no, please give us an estimate. Will you argue for 10 minutes, 20 minutes, half an hour?
My lordship, I have no argument. This is my case. This is a violation of Government of India's directive and Supreme Court's order, OPA Act and OGLS Act. That is my submission before us. That's what.
You have finished your submission?
My lordship. I'm sorry if I have bothered you.
No. We are asking you generally. If you want to make submissions, we're not going to stop you, but we just wanted to have an estimate of the hearing. We wanted to know how long will the hearing go on.
No, my lordship, I'm content. I'm content.
And there's a matter here is that there was some butcher land which has been de-reserved. Now in the state, my lords, under the OGLS Act, under section 3A, the collector, my lords, has the power to de-reserve land. There are certain conditions, and in this particular case, it was assessed that this particular butcher land was in excess of the reasonable requirement for the purpose for which it was reserved. So therefore, my lords, the government has taken a stand that this particular land has been de-reserved for industrial activities, and thereafter, my lords, this land has been given to IDCO, which has further leased it to opposite party number 5, which is setting up the cement plant. My lords. So with regard to, my lords, any infirmity in the order of de-reservation, under the OGLS Act, there is an appeal provision under section 7. The petitioner here has directly, my lords, come to this High Court without, my lords, exhausting the remedies under section 7, because that is an appeal provision, my lords.
All right. What is your case on merits?
My lords, in this particular case, my lords, the Gochar land has been de-reserved following the procedure under the OGLS Act. And the other, and under the OPLE Act, there was a field verification by the Tahsildar where 9 particular instances of encroachment were found, and they have been penalized, and that, my lords, will find at para 6 of my counter affidavit. So with regard to the de-reservation of the land and thereafter giving it to IDCO, my lords, there is no infirmity, and the state has followed the procedure under the OGLS Act. That is the sum and substance of the matter.
All right. Well, you're the Ramco.
Yes, my lord, I am for the OP number 5. My respectable submission before your lordship is only 2 points. So far as this, the averments of the writ application, if your lordship will go through, the averment itself is self-contradictory, my lord. If your lordship will kindly come to para number 5 of the petitioners, that in one hand, he is saying that the land was being encroached by the unauthorizedly by the OP number 5, and the averment number 10, that he is being aggrieved that the procedure of settling the land has not been duly followed. If that is so, my lord, as per the OPLE Act, my lord, I will draw your lordship kind attention to section 12. Because as per the the petitioners, the whole argument is that the procedure so far as the OPLE Act, my lord, has not been followed in a correct way, and the decision has been taken under section 7 or 8A of the Act, my lord. So the Act itself exhaustively dealt with all these situations, my lord. The appeal and revision provision has been enumerated, and
that's on the procedure part.
Yeah, yes.
What is on merits?
And second is that, my lord, their representation so far as because he has numerous ground so far as the land was settled so far as by taking all kind of due procedure by the IDCO, and thereafter the land is being given as on a lease basis to the petitioners. So question of settling is not as per the Act itself. And so far as the petitioners is concerned, my lord, at para number 17, their representation before as per the Act itself is pending before the authorities. Without exhausting or disposing or waiting for the disposal of the representations, they have moved these applications. And in the similar set of circumstances, another writ application was also filed. Your lordship has directed. In that case also, they have mentioned so far as other issues they have connected, endowment land, government land, and all these things. Your lordship has disposed of the writ application with a direction that their grievance will be taken care of by the authorities. And if it is found
then they can.
Where is that order?
My lord, that is itself in the this list, my lord. In 2017, writ application is attached, my lord.
26587.
Yes, my lord.
All right. That's it. Yes, Mr. Mishra, anything more?
My lordship, as my learned friend pointed, my lordship, kindly have a glance on Annexure 4 and Annexure 5, 2021. And I have approached the Tahsildar under Section 7 to inquire the matter and to redress my grievance. That is under page 2021. So also, the member board of revenue also, and they had directed the collector, my lordship, by page number 22 to inquire the matter, and that was not also accepted by lordship. That was not also carried out. But the collector and the Tahsildar board of revenue had already directed them to inquire the matter. That didn't happen also. Now, my lordship, my learned friend is depending on his counter averments. 8. They have collected 40,200 rupees as assessment fee. They have collected the assessment fee, my lordship. But under Section 7, it is mandatory for the state to evict the person concerned. If that encroached the voucher land, that was not accepted. They have mentioned that they have accepted the assessment dues, but are not evicted. That means he was under continuous possession of the voucher land. Continuous possession, my lordship. But if that was happened, then matter should not have come to this place, my lordship. So my simple submission before lordship, it's not only a violation of the Government of India directive and apex code, also their own guidelines framed by the state, my lordship. That's all, my lordship.
What is the result? Order is reserved.
My lordship, my submissions can be recorded.
Yes, yes.
Oblige, my lordship.
Supplementary list item number 16.
I'm on virtual mode, my lord.
Yes.
May I please your lordship?
Yes.
Lords, in this case, no notice has been issued, no counter has been filed as yet. My point is that we are the traditional fishermen in the Lake Chilika.
Let them file a reply, sir. Let them file a reply.
They are not filing, Lord. We are ultimately there will be murder for this purpose.
Yes, the department, I have issued letter to the department and yes. No, we have not filed the count.
We'll give them a last chance, sir. Last opportunity is granted to the opposite parties to file a reply within 4 weeks, rejoinder if any before the next date. Sir, have 7, 8, 13 been served?
Lords, we have already again filed requisites.
Oh.
Consignment details not found. All right. Fresh notice be issued. In the meanwhile, to opposite parties 7, 8, and 13. Return over by the next date. List on 12th September.
Supplementary list item 17. It may please your lordship, my lord. My lord, the opposite partner 3 got the appointment by producing a fourth experience certificate as associate professors of plastics born and plastic surgery department in AIMS Bhubaneswar, and that was brought to the notice of the authority, and the board of directors took the decision under at page 48 to initiate a disciplinary proceeding, my lord. As the board of directors was not satisfied with the reply of the opposite party 3, your lordship has granted time till today, my lord, to implement that board of directors decision at page 48 to initiate the disciplinary proceeding, and director has not yet initiated any proceeding.
Yes, Mr. Paddy, what's the latest? Mr. Paddy?
My lord, item 17.
Yes.
Yes. In that case, last occasion what my lord directed, and yesterday I received a information from the AIMS that they have issued charge sheet memo to the person concerned.
No, has the director and deputy director post been filled up?
No, my lord, this is till date the one of the from director from Bangalore, he is in charge. And
Okay.
the deputy director still I don't have any information in this regard.
Charge sheet has been filed in the disciplinary proceedings.
My lord,
When was charge sheet filed in the disciplinary
they
proceedings?
said charge sheet is only they have served on 21st.
21st of June.
Yes, my lord. Before 2 days, my lord.
You want them to file an affidavit?
Yes, my
Yes,
lord.
we will file an affidavit
Mr.
in-
Padi states that in the disciplinary proceedings, a charge sheet has been furnished to the delinquent on 21st June 2022. He states that he will file an affidavit to this effect within a week.
Yes, ma'am.
He states that the posts of director and deputy director of AIIMS Bhubaneswar are still lying vacant.
Yes.
The director, AIIMS Mangalore,
Yes.
is in charge, is holding in charge, is the in charge director of AIIMS Bhubaneswar. List on. Now there is a charge. They have started disciplinary proceedings. There's no urgency now.
Lordship, let him file the charges, then thereafter, my lord, copy my lord, your lordship may.
All right, list on 13th September. All right.
Supplementary list for hearing item 18. 18, I beg pardon, your lordships. My name has been wrongly reflected in the cause title. For that reason, I am not with the file today, my lord. I was appointed through legal aid, my lord. My name has been wrongly reflected in the cause title. For that reason,
Wrongly reflected meaning I don't understand. Your name is
Vikas Chandra
has it
in
been
place.
reflected or not reflected?
In place of Vikas Chandra Parija, it is written as BR Parija. For that reason, I am confused. I have not. With the
So
file.
what is that to be confused, sir?
My lord, in this matter, my lord,
Once you have the criminal appeal number, then you obviously know it is you. You are appearing for the appellant.
My lord, we are for the appellant, we are ready with the case, my lord. I pray only pastor, my senior will place this matter. One passage taken was the last case, my lord, only one.
All right. All right.
Lord, item 17, along with me, Mr. BK Patil name will be reflected.
All right. All right.
Item number 19.
19, so there is a report. That is a flag B. The appellant is dead.
It is a report stating that the appellant has expired. That view of the matter, the appeal is disposed of as having abated. All right.
Supplementary list item 20.
Pursuant to Lordship's last direction, my lord, we have informed the IAC. He has also served the notice on the appellant. Lordship, may kindly see Lordship's last order, my lord, 21/4/2022. The Orissa High Court Legal Service Committee was requested to assign a counsel.
Who have they assigned it to?
My lord, as it reflects from the list, my lord, Mr. Siddharth Swain's name is indicated. Also, Mr. C.R. Sahu, Mr. B. Biswan.
Has the appellant appeared?
My lord, today in the morning also I've reminded the IAC to go and ascertain his house, my lord. He has gone, the house is locked. He just informed me over phone.
Oh, so he's not traceable.
My lord, no, he has been served with the notice. Today in the morning, just to ensure his appearance, my lord, I asked the IAC to go. He has gone. Today the house is locked. He has been served the notice. I have the copy of the, my lord, acknowledgement.
Who's the legal aid counsel? Can you find out?
Mr. Siddharth Swain has been appointed.
Where is he? How can the legal aid counsel not appear?
Most likely, my lord, since Lordship had directed him to be produced today, he might have come also as well.
You just pass it over once.
Right.
Ask that Siddharth Swain to remain present. Must be having a mobile number. Yes, it was. Please tell the.
Supplementary list item 21.
Last time appellant counsel had appeared and had asked for time.
No, nobody appeared.
Okay.
One RK Raut.
Yes.
I think we'll cancel the bail. That's the best way, and ask the appellant to remain present. Because they're just playing games. He says he collect paper book, doesn't appear this time.
You also can direct to cause his appearance before this on court.
Sorry?
Cause his appearance of the appellant.
Yeah, best is to cancel the bail. From the previous date, one Mr. R.K. Raut, advocate, appeared and stated that he would collect the paper book from the registry and get ready with the matter. Accordingly, the case was adjourned till today. For a paragraph, today none appears for the appellant, who is on bail since 28th September 2015. In that view of the matter, the IIC was to inquire about the whereabouts. What happened? On 7th April, we had said the IIC will inquire about the whereabouts.
Report has not come. Noting is there, report has not come. I can ascertain it.
Mr. Katkia states that he will instruct the IIC concerned to ensure the presence of the appellant in court on the next date. Notice be issued to the appellant to remain present. And then you say Mr. Katkia states that he will instruct the IIC. Notice to the appellant, without process fee, be served through the IIC concerned to remain present in court on the next date. Mr. Katkia states that he will instruct the IIC in this regard forthwith. List on 21st July. 21st July.
Supplementary item 22.
Miller, please. I am from the Bachchan Miller.
Yes, please.
Miller, I may permitted to take the paper book, Miller. I've been
every time, sir. Every time you ask for an adjournment like this, you're not ready to go on with the matter at all.
No, my lord. For last chance,
last time order was passed. Last time also order was passed.
Yes, last time also the same order was passed.
I'm sorry, my lord.
No.
By tomorrow, I will receive that paper book, my lord.
No. Last time, 5th May, you said you will collect the same submission you made, sir. You said you will collect paper book and get ready in the next week, you said, on 5th May.
My lord, unfortunately, due to some illness, my lord, I could not able to.
You're never ready, sir. None of the matters are you ready to argue.
My lord, by tomorrow, I will receive that paper book and whenever my lord will put it, I will argue, my lord, in physical, my lord.
At the request of counsel, the appellant list on 30th June, it is made clear that there will be no further adjournments granted.
Supplementary list item 23.
May I please, Your Lord? In this case, my lord, the petitioner challenged the order of the sales tax tribunal for disallowing my claim of selling of product to the defense personnel, my lord. In this case, my lord, the petitioner is a manufacturer of Indian manufactured foreign liquors, my lord, who are selling its products to customers as well as the defense personnel, my lord. My lord, during the session 1999.
Anyway, who's for the
Your Lordship, I am appearing on behalf.
Yes. All right.
My lord.
Yes, please. Carry on.
My lord, during the assessment year 1999-2000,
Yes.
the petitioner has filed its return under Section 11 of the Orissa Sales Tax Act,
Yes.
claiming its GTO amounting to rupees 39 crores 12 lakhs 19,248 rupees.
Yes.
Whereas it has stated that out of those goods, rupees 1 crore 14 lakh 15,118 towards sale of goods to defense organizations. And after the assessment order, my lord, as per the assessment order, the assessing officer has disallowed the claim of that 1 crore 14 lakhs 15,118 of defense sales and demanded the amount, and by being aggrieved by the order, I preferred appeal before the first appellate authority. Whereas it was partially allowed, and the dealer company has claimed deduction of rupees, it was reduced to 1 crore 11 lakh 73,805 rupees, my lord. And again, being aggrieved, we placed the we approached the Honorable Sales Tax Tribunal, my lord, but it was disallowed there, claiming that the amount of rupees 1 crore 11 lakh 73,805 was not to the defense organization. Instead, it was to the dealers. My lord, kindly go to the Annexure 6 series, my lord.
Yes.
Whereas the State Excise Department has issued the permits to where it is clearly mentioned that for defense personnel only.
Correct.
It was an Annexure 28 to page 28 to running page 28 to 31, my lord.
Correct.
Yes.
No, doesn't mean that you actually gave it to defense personnel. They have permitted you to sell it to defense personnel only. What did you actually do is the question.
No, my lord. It is to the defense organization. The sale is to the defense organization, and
what is that to show to sale was made to defense organization?
No.
Where is the invoice of your sales to defense organization?
Those amount we have not sold directly to the defense organization, my lord.
If you don't sell it directly, then what happens? How will you get the benefit?
My lord, it was clearly mentioned in the State Excise Department has issued the permit, and on basis of that
permit allows you to sell it directly to the defense organization.
Yes, ma'am.
Pursuant to that permission, which was granted, for which the permit was granted, did you sell it directly to the defense organization?
No, no, ma'am.
Then how will you get the benefit, sir? That's the whole point.
No, my lord. If in this case, if I will not get the benefit, then I have to tax the collect the tax from the dealers. Then when the dealer will sell it to the defense organization, again they have to collect the tax. Then ultimately it will be the tax will ultimately on the defense personnel, my lord. The entry 29B says if any.
Let's see the entry 29B.
Your Lordship.
Sorry, my lord, I have written.
Your Lordship, that has been quoted also in the first appellate order, page 20 of the brief.
Page 20, is it?
Your Lordship.
Yes. Yes, my lord, running page 10, I have quoted that 29. Sale of goods to Defense Service Limited installation located inside the state of Orissa for resale to military installations and personnel.
So whom did you sell it to is the question, as simple as that.
Yes, my lord. Agreed, my lord. Some products which we are directly selling to the defense organizations, but some through dealers, my lord.
Your Lordship, whatever amount has been sold to defense personnel, that has been allowed by the first appellate authority.
Defense organization.
What was sold to the different persons, Your Lordship, that has been...
We are, my lord, we are not selling directly to the defense personnel, my lord. We are selling to defense organizations like NCC, etc., Coast Guard. In that case,
has been allowed. Those have been allowed.
Those are allowed. Yes, my lord. Agree. But in some cases, we are selling those goods. And in the miscase, my lord, you can kindly see the miscase. We have labels where annexed, my lord. In that case, it is clearly mentioned in the label. It was stamped as for sale to defense personnel only. That we cannot directly in the open market, my lord. That we cannot sell. So only those products we are giving to them, and they're giving it to the defense organization.
Who's them, sir? Giving it to them means who?
We are selling it to the dealers, my lord.
Ah, so that will not satisfy this requirement, sir. As simple as that. You
No.
say that will not satisfy the requirement. This is a tax law, sir. This is not a matter of equity. It only admits of strict interpretation.
No, my lord. If it will be charged, the tax will be charged on me, my lord. Then ultimately I have to collect tax from
That is all right. That is all your headache, their headache.
Your Lordship, Your Lordship,
my lord, please give me 1 week time so that I will, in support of this, I can give you some.
No. We're not adjourning. Yes.
Your Lordship, may kindly turn to page 19, the first appeal order, Your Lordship.
Yes.
Your Lordship, paragraph 4. Your Lordship, 10 lines below.
Yes.
At this forum, the appellant furnished a detailed list showing month-wise of sale of IMFL amounting to rupees 1 crore 14 lakh so and so, which has been claimed as deduction on account of sale to defense organization. On perusal of the list furnished, it is ascertained that the name of the party to whom the goods have been sold, C.K. Kakani Jharsuguda, Magta Sau Barampur, B.K. Sau Angul, instead of indicating the name of defense organization to whom the goods have been sold. Now, Your Lordship, may kindly turn to the next page. Your Lordship, and have been claimed further on verification of the Xerox copies of the sale bill issued by the appellant, it is ascertained that appellant has effected the sale of IMFL and raised bills in favor of Director of NCC amounting to 82,000, ARC Charvatia 38,000, Coast Guard Paradip 71,000, and 120 TA 48,000. So this amount is 2,41,313. Now, Your Lordship, the last page, the same page, the next paragraph, the last 3 lines. I do not find any merit in the contents of the appellant in respect of its claim of sale of IMFL amounting to rupees 1,11,000. 1 lakh out of 1,14,000, 2,41,000, whatever sold to the defense personnel, that has been allowed. And 1,11,000 has not been allowed, it has not been sold to defense organization. Now, Your Lordship, same thing by the tribunal. Lorraine Tribunal has perused the same thing. Your Lordship, at page 23. Page 23, paragraph 5.
Yes.
We have heard Mr. Chaudhary S. Mr. The Lorraine Council, so and so, the Lorraine SCST has not allowed the exemption IMF been sold to, like C.K. Kakani, Jharsuguda, Magta Sau, and Angul, but he has allowed tax exemption to the Director NCC, so and so, Coast Guard Paradip, for 2,41,000. The London Council for the appellant has filed Xerox copy of large number of bills IMFL has been sold to C.K. Kakani, B.K. Sahu, but there is no evidence on record to show that these dealers have received the goods IMFL to sell it exclusively to the defense organization, Your Lordship. No proof, Your Lordship. And the petitioner himself has claimed the exemption as per 29B, Your Lordship. And 29B clearly says, Your Lordship, that the sale of goods to defense service installations located inside the state of Orissa.
Yes.
Your Lordship, that's all, Your Lordship.
Hence,
29B is not applicable to the petitioner's case.
Right.
And rightly, Lorraine Tribunal has passed the...
My lord, in this case, my lord, it is the owners and the dealer. They have to prove whether they have exclusively given exclusively to the defense.
You have to show it, sir. You are also a dealer only.
We are selling them on the basis.
You are also a dealer only, sir. You are bound by the conditions.
Yes, my lord.
Yes.
We have the permits, my lord. So on basis of those permits, we are giving them because they have given us the permit. That is the proof with us. These things are available with us. These permits are with us, and these are the products which will be sold to the defense organizations. That's why in the permits it is written for defense personnel only. So basing on this permit, my lord, we have given those products with the seal. It is for defense personnel only to those things.
All right. The present petition by the SSC arises from an order dated 25th April 2008, passed by the Orissa Sales Tax Tribunal, Cuttack, dismissing the petitioner's appeal essay number 2864 of 2004-05, which in turn was directed against an order dated 21st December 2004, passed by the Assistant Commissioner of Sales Tax, bracket ACST, bracket Puri Range, Bhubaneswar, in AA.4/PU-2-K/0405. Full stop. As a result of the above orders, the initial demand. No, you see, while admitting the present petition on 17th July 2009, this court framed the following question for consideration. Reproduce the question. Paragraph. The petitioner carries on business in Indian-made foreign liquor, bracket IMFL, for the year in question, that is 1999-2000. The return filed by the SSC was picked up for assessed by the sales tax officer.
Page 16, Your Lordship.
The gross turnover, bracket GTO, bracket disclosed by the dealer stood at rupees 39,12,19,248. Full stop. The dealer claimed reduction of rupees 35,27,60,376.24 towards sale of first point tax paid goods. Full stop. The dealer was found to have purchased IMFL to the tune of rupees 19,17,69,427 from Utkal Distillery Private Limited, Khordha. On this basis, the reduction as claimed by the petitioner was allowed. Full stop. Paragraph. The petitioner further claimed deduction of rupees 114,15,118 towards sale to defense organizations. Full stop. However, according to the STO, since the petitioner failed to produce any evidence in support of such transaction, the deduction was disallowed. Paragraph. When the petitioner filed a further appeal before the ACST, to the extent that he was able to produce, the petitioner was able to produce proof of sales to defense personnel and defense installations, the deduction was allowed as paid for. Full stop. Sale of IMFL amounting to rupees 1,117,3,805 out of rupees 1,14,15,128 to defense organizations was not allowed as a deduction, since the appellant had failed to produce necessary evidence in support thereof. Thereby, the appeal is allowed in part. Paragraph. The further appeal by the petitioner to the tribunal, to the extent that the ACST had not allowed its claim to the above extent, was dismissed by the tribunal. Full stop. It was held that the goods to the extent disallowed had not been sold to defense organizations. Full stop. What emerged was that the sales had been made to 3 individuals, that is C.K. Kakani, Makta Sahu, and B.K. Sahu, without any conditionality that they could in turn sell it only exclusively to defense organizations. Paragraph. This court has heard the learned counsel of the parties. Stop. The relevant entry 29B of list A of the rate chart appended to the Orissa Sales Tax Act reads as under. Take from page 20 of the paper book. Paragraph. As rightly interpreted both by the ACST and the tribunal, in order to claim exemption from payment of sales tax, the burden was on the dealer to show that goods had been sold to defense service installations located inside Odisha for resale to military installations and personnel. Factually, the petitioner was unable to produce evidence in support of sales to the value of rupees 111,73,805, which satisfied the requirement of the above entry 29B. Full stop. In other words, while for the remaining amounts, the sales made to defense personnel or defense organizations for which proof was produced by the petitioner was allowed as deduction. The sale to 3 individuals, as noted herein before, was not treated as sales to defense service installations. Paragraph. Counsel for the petitioner sought to refer to the entry in the permit issued to the petitioner, which bears the entry, open quotation, for sale to defense personnel only, unquote, and claimed that the consignments themselves bore a similar stamp, and therefore, although the sales were made to individuals, they could in turn sell it only to defense personnel. The court is not impressed with the above submission. The requirement of entry 29B is that the dealer should have sold the consignment to defense service installations and at the highest to defense personnel, and not to individuals in turn who may or may not have sold it to defense personnel or defense service installations. In that view of the matter, the court is unable to find any error having been committed either by the ACST or the tribunal that calls for any interference. The question framed is answered in favor of the department and against the SSC. The revision petition is dismissed. The interim order is vacated.
Obliged units. Brief.
Supplementary list item 24.
So do you upload this item 21? I want a free copy, plus. Item 21.
You want a
free copy of the order, please.
Okay, it will be open to Mr. Katkia to collect a soft copy of the paper book from the registry and supply of paper of a pen drive.
Item 24.
24.
24, but as it appears from the cause list, some other name. It is state case. 24. I was initially assigned this matter, and from cause list is Mr. Sujit Kumar Gupta name.
If you're ready, you carry on, sir.
Yes, yes.
Yes.
The day before yesterday, I collected the paper books.
Yes.
Straight case, 5 eyewitnesses. Straight case, 5 eyewitnesses directly, no cross as good as no cross examination.
No
cross examination as good as.
Oh,
that is entire evidence I have gone through. No rebuttal evidence, nothing there. Only I can argue before your lordships.
Yes,
all the witnesses are the relatives.
Right.
No independent witness is there.
Okay.
Number one. Number two, he is in custody since 2007.
All right.
And meanwhile, 15 years, 3 months. And PW 1 and 2,
yes,
who have stated that they saw the accused appellant while he was running away on the road.
Right.
And they snatched away one seizure.
Right.
Seizure.
You know his name? Just give your name in a slip of paper.
Ashok Kumar Behra.
Ashok Kumar Behra. All right. Yes.
The allegation is the appellant has asserted two.
Yes.
First, to the PW3, who is the nephew of the deceased.
Yes.
By means of seizure. And when the deceased opposed him while
yes.
assaulting to his nephew,
yes.
he stabbed on his chest by means of spear.
Right.
Farsa. But the evidence of PW 1 and 2 shows that he was holding only seizure. They have snatched away from the appellant.
Yes.
And so far as defense pleas concern the mental disorder, that has been discarded by the
right, because that burden is on the defense to prove it. Then correct.
No proof is there. No.
Right. That's it. All right.
Madam.
The doctor's
Only
evidence.
broken seizure was
that is 46 page 46 plus.
As it
PW 9. One penetrating injury situated over the right chest in front size 4 cm and 4 cm. The injury was situated over the right 7th rib space.
So there's only one penetrating injury.
Only one injury is there, and it cannot be possible by the spear, as has been.
Paragraph 3.
Spear has several points. Spear or child master.
And who are the eyewitnesses? PW 1, 2, and 3.
Yes, no one. No, they have stated that we are returning from.
No, I'm asking
5 plus PW 5, 6, 7, 8, and 11.
Oh. 5 is Trinath Santa.
Ratana
Santa.
Yes. 1 page was total cross-examination.
Was caught red-handed.
My father was also with me. The accused suddenly came to our house and dealt a blow by means of a spear on my father and went away from the house. Then we chased the accused and caught red-handed the accused. Samar, Ibaru, Buster were also with me while chasing the accused. We brought the accused to our house. Ibaru and she went to the police station.
And nothing in the cross clause you also can find.
Mm.
Same is the case in PW6.
But
One
it was
page.
contradictory to the 161 statement.
But there's no confrontation in the cross-examination, sir.
That is it.
That's the whole problem.
And
nothing has been cross-examination, only suggestion was given that he was not present in the house. What he has stated before the eye.
PW6 stated, while I was coming after taking bath, found the accused dealt a blow by means of a spear on the chest of my father. As a result, he died. Then PW7 also said, I was in a house, my husband was also in the house. The accused suddenly came to our house and dealt a blow by means of a spear. As a result, he died at the spot. Then the accused running away after committing murder. The villagers caught him red-handed.
What was the reason behind the assault?
PM report is doctor.
What is the reason behind the assault?
Motive.
Motive. So direct evidence there was motive, no that.
That's right. Mm.
Direct eyewitness account.
And the villagers snatched away only once a
They
seizure.
caught him red-handed.
Right.
Caught him red-handed and snatched the one only seizure.
All right. All right. Orders reserved, sir. Order.
Supplementary list item 25.
Item 25. Please, Millards. That's the event, Millards, dates back to 2015. 2015, it's an unfortunate event which happened. But thereafter, Millards, the prayer here is to set up an SIT. In the meantime, Millards, the police has proceeded with the matter. The charge sheet has been filed, which my lords will find in my comprehensive affidavit.
Let's see that.
Please, my lords. The charge sheet starts at page 9 of the affidavit.
Where's the
Comprehensive affidavit filed on behalf of OP 3 and 4.
Comprehensive. Yeah. Yeah.
As out of 9 accused, Millards, 2 are in judicial custody and the trial, Millards, hasn't started as per my latest instruction, but it is at the stage of trial. Against the other 7 accused, Millards, NBWs have been issued, but they are not in judicial custody as of today.
For 7 years now.
But these 2 Millards were arrested right after the incident. Millards, not right, but after a delay of about a month. These 2 were arrested, but the rest 7 Millards are absconding as on the date of filing of the charge sheet, Millards. And Millards, in fact, the police has now have drafted a SOP, Millards, as to how to deal with these. Millards, the incident was like this. There was a decision taken in the university to cancel the elections. Thereafter, Millards, there was a peaceful protest. In fact, certain police personnel were there. But in the frenzy of this whole demonstration, certain errant students came to the national highway, which is because the Vanivihar University is just off the highway, 50 meters away from the highway. So they came on the highway and started a blockade. In the meantime, Ms. Miller, the deceased lady, she was in her car. So they have apparently charged towards her. And she had a unfortunate incident of Miller's aneurysm. So there was a brain rupture and she was immediately rushed to the Capital Hospital, which is Miller's the state-of-the-art hospital in Bhubaneswar, Miller's government hospital. And at 5:45 Millards, this incident happens. At 6 p.m., she is declared dead, Millards. So, Millards, if Millards will see page 6 of the comprehensive affidavit that we have filed, para 5, Millards, the corrective steps that Millards, the police is taking with regard to Utkal University in particular. That, however, to tackle this kind of situation in future and to prevent recurrence, some preemptive policies have been adopted covering different ways and means, such as Unauthorized occupation of passed out students in the hostels were kept free by the university authority. One side of the main gate of the university is kept closed always to prevent immediate rushing out of students from the campus to the road. Security personnel have been deployed by the university authority 24/7 at the main gate. Continuous liaison with student leader and university administration is being made to collect advanced intelligence to prevent such type of occurrences. Dedicated static force has been deployed at Shahid Nagar police station to meet any untoward situation. One police officer in the rank of DSP and 3 police constables have been deployed inside the campus to meet any eventuality. Millards, and in the last couple of years, Millards, such an incident.
This costs of 5,000 were paid or not?
Please, yes, Millards. That Millards will find in the counter affidavit, which is filed on behalf of opposite party number 1 and 2. At page 34 of that counter, annexure C/2.
All right.
But there is a direction of this honorable court, all the opposite party has to pay 5,000 each.
Yes.
But as per OP number 5 is concerned, I have not received the copy of the affidavit. Whether they have paid 5,000 or not, as far as OP number 5 is concerned, it's not known.
I am for the OP6, my lord, for university. I have already paid the cost, my lord.
OP number 5. OP number 5 is the IAC, Shahid Nagar police station, my lord. He is also, he is a necessary party. He has also to pay 5,000 and file counter affidavit. But I have not received the copy.
No. If he has not filed counter affidavit, he doesn't have to pay 5,000. Those who have to pay are the ones who have to file.
Because the counter affidavit on behalf of the police has been filed by the Deputy Commissioner of Police. The IIC filing a separate counter.
Only
Millards, my short prayer, Millards, is that in view of these affidavits, Millards, let the trial proceed to its logical conclusion.
That nobody's preventing it from
proceeding. Millards, then the prayer, Millards, in my humble submission doesn't survive, Millards, because it's been 7 years now, and Millards, the investigation is completed, and Millards, the trial is proceeding. The police has taken active steps, Millards, and thankfully, Millards, such kind of incidents hasn't happened, Millards, and will not, Millards, happen hopefully in the future because the police is now on top of it.
I may be permitted to place some facts.
Yes.
I am not aware. This is a PIL matter, my lord.
Yes.
Matter relates to a death of a energetic young lady, namely late Suman Sharma, on 26 September 2015 on the National Highway in front of Utkal University. This matter appears today's release as per the order number 16 dated 22nd March 2022. On the said that this honorable court has directed to file a rejoinder, my lord.
Correct.
As per the order and direction of this honorable court, the petitioner has filed rejoinder to the counter affidavit dated 3rd March 2022. Then I would like to first of all draw your lordship kind attention to para 6 of the counter affidavit dated 3rd March 2022 of the opposite party 1 and 2. Para 6, my lord, which finds place at page 4. In this set, that is the last 3 lines of the said paragraph are relevant, where it has been said, since the investigation was being conducted by the Commissioner of Police, it was not felt necessary to have a special investigation team. It is contrary to the law, only because Commissioner of Police is a necessary party and he is a prosecutor and judge of his own cause. So my submission before your lordship, if they say that special investigation team is not required to be conducted.
In that case, every case there should be a special investigation team then.
My submission before your lordship is that the commissioner is a necessary party, he is a prosecutor and judge of his own cause.
There's no judge of his own cause, please. There has to be only the police can investigate. And the police has to file a charge sheet. They're not being a judge.
My lord,
the court will decide whether the charge sheet makes out an offense, doesn't make out an offense.
In that case, I want to submit before your lordship that when the commissioner conducted the investigation, no opportunity was also given to the petitioner to participate in the investigation.
Why would you participate? I don't understand.
No.
You are just one organization, please.
No,
Where's the question of you are participating in the investigation?
We should know, sir, what is happening.
No. Where do you get all this? Where do you get this?
My lord.
Please see the CRPC. Where do you get all this?
My lord.
That any NGO will just participate in investigation. Where do you get all this?
But we have prayed for a special investigation that was turned down.
You should show why, according to you, the investigation is not fair. The investigation that has happened so far, you should be able to show why it is not fair.
The trial is going on. We have to see that what is happening there.
Exactly. So when the trial goes on, only you will know then.
Then there will not, no, sir. That apart, my lord, I want to draw your lordship kind attention to another facts, which are also very relevant. The accident victim was carried to the capital hospital, my lord. Though there is a hospital nearby, that is in front of the Utkal University, my lord, but the victim was not carried to that place. Instead of that, they have carried the victim 5 to 7 kilometers away, my lord. I would only to draw your lordship kind attention to my rejoinder annexure 1, my lord, where a specialist hospital was there, that is Sports Hospital, my
That
lord.
is not part of your prayers at all. Just come to your prayer in your petition, sir.
My lord.
Please come to the prayer in your petition.
My lord. In our prayer, my lord, we have paid for setting up a special investigation to
So
conduct.
nothing about lack of proper treatment to the victim. That's not your prayer.
Proper treatment was not done, my lord. In our rejoinder, we have said that no proper treatment was given.
All right.
And that has been carried to the capital hospital, which is 8 kilometers away from the place of occurrence, my lord.
But they have not asked for any release on that basis, sir. Yes.
Only I to place, my lord, annexure 1 to my rejoinder.
Yes.
I may be permitted to draw your lordship kind attention to my rejoinder, my lord. Rejoinder file to the counter affidavit dated 3rd March 2022 to the counter affidavit filed by OP number 3 and 4, my lord. Your lordship got it? That is annexure 1, page 6, my lord. That is in a hospital, specialized hospital situated nearby. But they have, instead of the victim was carried to that hospital, it was carried to 7-8 kilometers away to the capital hospital. Annexure 1, page 6, my lord, to our rejoinder affidavit. They should have taken the victim to that hospital, my lord, the Sports Hospital and Critical Care, which is adjacent to the capital, to the Sahid Nagar police station, my lord.
Yes, yes.
Very nearer. Only that should have been taken care of. But they have not taken to this is very nearer. And specialists, they are saying that there was no such hospital there. Only no good hospitals is available, but it is available there. They should have given that. That apart, my lord, the duty and responsibility of the police, there was an occasion of the Supreme Court to deal with the matter when there is any disturbances in the highway. how the police used to deal with it. For that reasons, I want to draw your lordship kind attention a judgment of the Supreme Court, which has been reported in AR 983 Supreme Court, my lord. In case of Rupendra Singh versus my lord, where their lordship has held, my lord, the duty and responsibility of the police. But the police, I may draw your lordship kind attention, page 66 copy of the judgment I am going to place before your lordship. The duty and responsibility of the police. Yes. It has been held that, but the police whose duty is to enforce law and order in the work of threatened mass agitation, which are reasonably likely to lead to a breach of public peace, are entitled in the discharge of that duty to impose reasonable restraint on the physical movement of the members of the public in order to the protection of public property and avoidance of neediness in the convenience of other citizens in their lawful action. But all such restraint on personal liberty, if at all, have to be commensurate with the object which furnishes their justification. They must be minimal and cannot exceed the constraint of the particular situation, either in nature of duration. Above all, they cannot be used as an engine of oppression, prosecution, and harassment, or like this. This main paragraph is that the sanctity of the person and of the privacy has to be maintained at all cost, and that cannot ever be violated under guise of maintenance of law and order, my lord. So my submission, the police has miserably failed, my lord. If the tear gases should have been applied or the flag march should have been done, the student mass should have been dispersed. They have not done so. Only students disturb, there is no problem, my lord. They should have applied the tear gas. If they have applied, should have applied the tear gas. The students should have.
How will the victim have been saved, sir? She was
My lord.
inside a car.
My lord.
Whether they use tear gas or not, as far as the car getting stuck in the traffic jam, how would that be solved?
But the police should have taken certain flag march, other things. They have not done so, my lord.
Sir, how will that have answered the situation where the victim was stuck inside her car in the traffic? Assuming that the police fired tear gas or did not fire tear gas, as far as victim is concerned, what could have happened?
My answer to that question is, my lord, if the students should have been deterred, then the car should have been passed. So that there should not be any congestion, or that should not be crowded. Where the car should not be stopped, my lord.
Yes.
Easy pass.
Yes.
Easy flow, free. But that has not been done, sir. For an innocent, but my submission before your lordship that the innocent persons, like this lady, has suffered a lot, my lord.
Correct.
What is their fault? There is
Correct.
no fault.
There you're right. An innocent person has suffered.
My lord.
The question is whom should we fix the liability of for that? That's the only question.
Liability can be, my lord, if your lordship pleases. Can we fix the departmental proceedings during that relevant period? Who are there?
Not on what basis, please? You should make out a case.
My lord,
you can't have a mere emotional appeal like this.
My lord,
you have to analyze the facts and tell us why do you think that the police was negligent or remiss in their duty?
Negligence only because the police has failed only because they are not able to disperse the crowd, my lord. The students' crowd could have.
It's a spontaneous crowd, sir. Suddenly elections are cancelled. The entire student body is coming out on the streets.
Then in that case, the national highway should have been somehow be blocked, or other steps should have been done, my lord.
All right.
I would like to place the judgment of the Supreme Court, my lord.
That's there. You've already given us.
My lord.
Rupinder Singh Sodhi. We have a copy here.
My lord.
All right.
In that case, the police, as per the judgment, the ratio of the judgment, the police has not taken that steps, which are the innocent persons has been suffered, my lord.
Right.
It is my submission before your lordship.
All right.
And some observation may be made if your lordship so pleases that in future this type of should not be continued. And should police should take precautionary measures.
I think we'll dispose of the writ petition. We'll pass a detailed order.
Grateful.
Or the writ petition is disposed of.
Pastor matter. Supplementary list pastor matter item number 18.
Well, first of all, I must make apology for being not being able to appear on the last date when the matter was just before vacation, because I am on my legs in the other court. Unfortunately,
So we'll take it up next Friday, next Thursday, sir.
Next Thursday. Well, it
All
will
right.
take
At the
some time.
request of Mr. Manoj Mishra, this next Thursday. Right.
Public.
Pastor matter item 20.
You speak to that, sir, that's fine. It appears from the office noting that the matter was assigned to Mr. Siddharth Swine, panel counsel of the High Court Legal Services Committee. He is, however, not present despite a passover. The Secretary, High Court Legal Services Committee will seek an explanation.
Who had come 3 minutes back?
Who has come?
C.R. Sahu.
C.R. Sahu.
C.R. Sahu. Chittaranjan Sahu.
The doctor will keep it to Thursday, and I'll inform him.
You said despite a passover, none appears. The matter appears to have been assigned to one Mr. Siddharth Swine, whose name is reflected in the cause list, and he also does not appear. A copy of this order be sent to the Secretary, High Court Legal Services Committee to ensure that Mr. Swine is present in court on the next date. List on 30th.
Weekly list, old matter item number 1.
Anyone
Yes,
present? You're
wherever
present for
the-
some matter, sir? Are you present for some matter?
Yes, my matter item number 8.
8. You're ready with the matter?
No, my lord. No, my lord. One of the appellant has been expired.
Yes.
On 28 2012.
Which appellant, sir?
Jail criminal appeal number 95 of 2004.
Okay. Jail Criminal Appeal 95 2004. Counsel for the appellant informs the court that the appellant has expired. The appeal is accordingly disposed of as having abated.
And another appellant, jail criminal appeal 31 of 2012, Orissa and Pechi, Parikitha Bera, has become psychopath. I have not got the information correctly.
No, he's
I
there
will
in the
seek
list.
instruction from.
No, he's there in the village. I have got the instruction.
So kindly call to his chapter. I will prepare. I will submit.
Who were present in their village, but only Dhoina and Dhaneshwar Bear have died.
The others are present in the village.
Yes.
Jail criminal 31 2012, appellant has become psychopath mad. Now roaming on the road. I have not got correct information from the criminal appeal number.
Anyway, we call it
71
next
2006.
Yeah. The remaining matters call next Monday, next Thursday. Right.
Madam, next 2 weeks time maybe. 2 weeks time.
No, next week, sir, get ready with the matter. Yes. Anyone else present?
Your Lordship, in item 3 and 4 in the weekly list, on behalf of Mr. Panda, I pray for next week, Your Lordship.
All right. If we stay on board.
Obliged. Your Lordship.
So item 2, some report has come that is at flag B, loss we can pay. And item 1, I have to ascertain the whereabouts of the accused. I have not ascertained. In the meantime, I'll ascertain.
Item 2, what is the report? Flag B.
Flag B. Flag B also.
Item 10 million, item 10 million. I prefer some time, 2 weeks time for.
Next week,
They're
sir,
alive.
get ready.
They're alive.
They're not
And now
going.
staying at.
If Lord stay on board, you get ready next week.
I mean, pardon, my lord.
Dulu Mahapatra. Who's this one, right? Oh. They are all present in the village, sir.
Yes, ma'am. That is plus instruction dated 16th 11/2020. Found they all above noted accused persons are alive.
Anyone
and now
appear in
staying at
item
village.
2? Okay, in item 2, you say the report of the IIC indicates that all the 3 appellants are present in their respective places of residence. None appears on their behalf. Notice will be issued to each of them through the in charge of Beden police station, who has submitted the above report to ensure their presence in court on the next date. Meanwhile, the Secretary of Orissa High Court Legal Services Committee is requested to assign a lawyer of not less than 10 years experience for the 3 appellants. Complete set of the paperwork be made available by the registry to the Secretary OHC LSC, who in turn will provide it to the assigned counsel. Forthwith. The said counsel will get in touch with the appellants for instructions before the next date. This on 21st July.
I may be kindly pardoned, my lord. My lord, I may be kindly pardoned, my lord. 30th is one of the cases outside Kattao.
It's okay. That you postpone, sir. You remain here for the High Court.
My lord, on 28th, your lordship may call.